listening to Legacy Lawyers, hosted by Michael Haslam and Nathan Croxford.
Hi, everyone. Welcome to our podcast today. What's up, Nathan?
What's going on?
It's holidays. It's go time.
Nothing says holidays more than talking about dead people.
Yeah. No, wait, no, that doesn't. It's time for you.
That's what you decided.
Oh, sorry. It's time for you to put to good use your beard.
Oh,
Santa Claus Nathan.
oh yeah. Need to get some white, whatever they put in their beard it's turning white, but it's not all white.
It's not there yet.
Eventually it will be all white. I promise you that. Yeah. So you decided that the last podcast we would record before the Christmas holiday was going to be on dead people.
Oh, I guess that is true. Maybe bad timing. It's kind of but this isn't estate planning. So I think about 80% of our podcasts talk about what happens when people die. So It's hard to avoid.
And as far as I know, 100% of people die. So
this is applicable to everyone.
It's very applicable.
So it applies to everyone.
So to start out, we are estate planning attorneys. We deal with HIPAA laws all the time in various circumstances, most often in creating estate plans that contain healthcare directives. We always pair separate standalone HIPAA waiver with our clients' healthcare directives just to make sure we covered all our bases. But the purpose of today's podcast is for educational and obviously entertainment purposes only and should not substitute as legal advice. So please seek out a qualified attorney to help you if you have questions relating to this subject matter. So what happened that made you want to talk about death right before the holidays?
There was a death, fortunately, and it wasn't your typical order, right? A lot of times it's our parents passing away or someone older than, right, our grandparents.
So it's a super bad death on top of everything else.
Yeah, it's a reverse situation. Someone lost a child, right, to an accident. And so the person was younger. And we've seen this before. It's not just this case. We've seen it in other cases, right, where a parent loses a child. And if they're younger adults, they usually haven't done any estate planning.
Yeah, and if they're minors, this isn't required because automatically parents are going to have access to their own children's parents or permanent guardians are going to access. So this would apply. So you're saying this was an adult child that passed away and the parents were in a position where I think they needed information, medical information.
Exactly. Yeah, there was some details of the accident they wanted more information on, right, which is medical, and they wanted a little more detail understanding the cause of death and some of the medical aspects of what happened to their child, which I think as a parent, you would really want to know all that, right? I mean, you really for closure.
Yeah,
process.
A lot of reasons.
Yeah.
I mean, you might, sometimes this was an accident, but if someone dies unexpectedly, sometimes people want an autopsy to figure out what went on, to find out, is this a problem that our other kids should get tested for? Was it suspicious? That kind of thing. So
yeah, there could be a lot of scenarios where you'd really want to know some of the medical information related to your family member's death, and it could go the other way, right? This
absolutely, yeah.
But it could be your parent, like, wait, what's going on here? So there's this law called HIPAA out in the world, and it is designed to protect what everyone refers to in the business as PHI, right? Personal health information. So
HIPAA is an acronym. HIPAA is an acronym that I'm going to take a stab at it.
Okay.
The Health Information Portability Act, but I'm missing
Accountability Act.
Oh yeah, Portability and Accountability Act. I think you're right. Let's look it up real quick, but I think that's it.
And I might have misspoke on the PHI. Did I say personal health information? It's protected health information is what
I think I've
Act
heard it used both ways, but the act probably.
calls it. I think the technical definition is protected.
Yeah,
So
you had it right. Health Information Portability and Accountability Act. And it was passed in 1996. And it's a pretty serious, like people, it's taken very seriously.
So anyone who's considered what they call a covered entity, so most, healthcare providers, they have to follow this HIPAA rule and not disclose information. So
Yep.
they're careful about it. They're very careful about it. And so when someone passes away, that law does not just end. It's like, oh, they're gone. We no longer have to protect their information. It's still in force actually for 50 years. After 50 years, I guess you can go get people's medical information, Nathan.
Yeah.
Which could maybe be for science. I don't know why they drew the line at 50 years.
I just think it's probably, even certain government information becomes available after
A certain amount of
a period
time.
of time. I think it's because pretty much anybody that would have had, I think it's because a lot of people around that person would either be deceased or I actually don't know why 50 years, but
The more you think about it, it seems weird.
yeah, because 50 years isn't long enough to make sure everybody would be deceased.
But I don't know, like if the information came out that much, because there can be some like embarrassing things in health information.
Yeah, that's true.
So, I mean, is it less embarrassing after 50 years? Maybe.
Probably not. So this came up, and I guess what happened is they wanted this information, and the covered entity, the healthcare provider, probably refused to provide it and
Yep.
cited HIPAA as the reason.
Exactly. Yep. Parents asked for information on their asked for their child's medical records, and the provider said HIPAA doesn't allow us to provide that to you. Then the question becomes, is that correct, Nathan? Or were they not allowed under HIPAA?
Well, based on the little bit of research we did this morning, I think they did the right thing.
I think it's kind of gray. You think the medical provider did the right thing?
Why is it gray?
So we can circle back to what the family had to do to get around this rejection. But the rules say that there is an exception that allows them to disclose information to non-personal representatives. They can just, as long as the information is relevant to the person's involvement in the decedent's care or payment of care.
So tell me what circumstances you know of that made it so that was applicable.
Well, I mean, their parents are family, so that's the first thing, right? The person's involved in they're the person who's taking care of their estate. The family had signed a small estate affidavit saying that they're stepping in as a unofficial personal representative for the family, and that information.
Sorry, I didn't mean to interrupt. Go ahead.
And that information, so that person is involved in the person's care or potentially the payment of their care, because they would be the ones paying their medical bills if there are any that end up being outstanding. So I think there's an argument that they fit into that exception. The parents do.
So is this person was not married, didn't have a significant other, didn't have somebody else that was taking that role? The parents were taking that role?
Yeah. They were single. They weren't married in this case.
All right. That makes sense.
Now, the same statute says the medical provider, if they've received specific instructions not to provide information to this person, that family member or other person, because it doesn't have to be family, but that's kind of the obvious candidate. But then they should honor that after they pass away, right? If they said, no, don't share that information with any of these people, then I want you to honor that still. So that's kind of where we don't have all the details of the reasoning. The medical provider said, no, we're not going to give this information to the parents. But I think this rule is broad enough that they could have given them the green light if they wanted to.
So you kind of hinted at it, but it sounds like these parents had to take some legal action to overcome this.
Yeah. So since the medical provider said, hey, you don't fit in this definition of a person that was helping and entitled to care, then the only other way we can share this information with you is if you are appointed as the personal representative for your child.
which requires probate. So a probate was required. There was, as far as we know, not any assets that required probate, but
No.
in order for them to get the medical information, they had to go through a probate proceeding and get appointed by the court as the executor or the personal representative of this deceased child's estate.
Yeah. So like, people say, hey, I don't have any money, so it's going to be my family. I don't need to do any planning. It's going to be easy. This had nothing to do with assets.
Or they say, hey, I mean, people might not say this because it would require doing some deep research into HIPAA, but you might say, well, the people that are around me are going to fit into these exceptions and they're going to be able to access my information. And I guess what I would say about that is maybe, but even if the covered entity, the healthcare provider, was not justified in denying it, how are you going to get around that? The only way you're going to get around it is to probate. So whether they're right or wrong, I guess you could have an attorney draft a demand letter, but again, the second you're doing that, you might as well be doing a probate.
Yeah, and like that's the the analysis we did when that client came to us is, okay, do we fight the entity and say, no, we fall under this exception under the HIPAA rules, you need to release the information? Or
it's going to be way cheaper to go just get a straightforward probate than it is to litigate over whether or not the person fits into that category.
Yeah. I mean, on principle, what you don't ever litigate on principle. I mean,
some people do. If you do, you make sure, if you're the attorney, that you collect a nice, healthy retainer, because people who litigate on principle sometimes get tired, and when it stops making financial sense, which is almost immediately when it's on principle, then there's people change their mind about how badly they want this. I guess it's not a given that probate would be the easier route. In this case, it sounds like, but if you had a really messy family situation where somebody was going to contest the person seeking medical information's right to become the personal representative, then you end up with a contested probate that could cost as much as actually suing the entity, the healthcare provider, for wrongfully withholding that information. So I guess it might be a theme that comes up once in a while in our podcast, but I think what we're saying is that it's better to plan for this in advance than it is to take a chance and hope your family's able to deal with the consequences.
Yeah, so let's talk about that practicality, right? In this case, it's just not common for young adults to do any estate planning, but there are 3 documents they should do, even if it's just like they find it on the internet. It's better than nothing. And one of them should be a HIPAA waiver. So what's a HIPAA waiver, Nathan?
It's a document that says, we understand that I understand that there's a rule that protects my private health information. However, I specifically want to allow the following people to access that information, and I waive my HIPAA rights as to them. So basically, it's an instruction to a healthcare provider that these are the people I would want you to disclose information to, for a variety of reasons. Maybe they are part of the team that's going to decide, whether another procedure is merited in an end of life type scenario, or if it's better to just let somebody pass away more naturally. Or maybe they're not decision makers at all, but they're people that you would want to be able to be in the room and be part of the discussion and have the doctor explain what's going on and, be part of the discussion. So there's a lot of reasons that you would want it, but basically it's a document where you're telling all of your healthcare providers that it's safe for them to release that private health information to the individuals you've designated.
And you can put that in with your healthcare directive, which is like your healthcare power of attorney, or it can be a separate document. We do it as a separate document because sometimes we have more people on that than we do on the healthcare.
And I think the one that we do as a standalone is more comprehensive than the one that's kind of included in the healthcare directive.
Yeah, the healthcare directive one could be a little light.
It's like what, 3 lines or something?
Like, what are you really giving permission there? So, and then if it's in those places, then after someone passes, that can be used as long as the document doesn't say it terminates upon death. So it's a good idea to actually clarify that it can be extended. It continues, the waiver continues after death.
Yep.
Then a financial power of attorney document is a really smart idea for anyone who's early in life, because if you become incapacitated, your family gets stuck going to court to become your guardian. And then a will. A will is a good idea, no matter what amount of assets you have.
Yep. I agree 100%. Those are the minimum documents you'd want to have.
I thought you were going to disagree with me, Nathan.
No, I know I disagree sometimes, but I'm on board. The day you turn 18, it'd be a good idea to put those in place, because you go from being a teenager that your parents can help to
a teenager that your parents can't help.
Teenager that your parents can't help. I was going to say teenager. So I have a couple of family members that they refer to kids that are over the age of 18 as marginal adult, but they're not marginal adults from this perspective. From the healthcare provider's perspective, they're adults whose rights are, protected just as much as somebody who's my age or your age. So yeah, you would want to have this.
Yeah. And if you have a estate planning attorney you work with, maybe they can just give you some basic forms that you get your marginal adult to sign, and then you can take care of them until they become full adults.
That's right.
You can help them out. If something comes up, you can help them out still.
The other thing that I've noticed, because believe it or not, I have children I have some marginal adults in my house, is that you can keep your kids on your health insurance until they're 26, I think.
Mm-hmm.
So here's where it becomes interesting. You're the one that's paying for the care, but they're the one that are signing for everything. And just the other day, my daughter had a procedure earlier this year, and there must have been a small overpayment or something, because the care provider sent us a check in the mail for a small reimbursement. And I'm getting ready to just drop that in the bank account, and I realize, it's made out to my daughter, because she's a marginal adult. She's over the age of 18. And so that's another good thing to consider, is that if you're going to continue to be financially responsible for your children's health care until they're in their mid-20s, then you're going to definitely want to have that HIPAA waiver so that you have the ability to deal with these issues. Yeah.
That's very true. And so, and I mean, this is a whole nother topic of this is now a parenting discussion. What about the kid that's my private information, Dad? I don't think.
Oh gosh. Then that's the day that I go, awesome. Then I'll go ahead and remove you from my insurance plan, and you can go find your own health insurance.
I don't need to know anything. I don't need to know anything.
I won't ask any questions. It was funny because
you got this.
It's funny because my daughter was like, well, can I, because I told her just deposit this and then Venmo it to Mom. And she's like, well, what if I just keep it? And I said, well, that's fine, as long as you pay for the entire procedure. As soon as I see that you've repaid me for the entire procedure, then I'll go ahead and give you the refund.
She just refunded you, huh?
No, she's not going to do that.
She's not going to pay for the procedure.
She might get away with depositing it into her account and not Venmoing us the money, because she's my only daughter, and
She
kind of
that's
she kind of has some she's got some
hours.
pull. She's got some pull. She definitely does.
Yeah, she gives you that smile, Nathan.
Oh, it's possible, and that's exactly what she did. She gives me that smile, and she looked at me and said, "It's gas money." I'm like, oh my gosh, you are killing me. If it was one of my sons, it'd be a no question. No. But when it's my daughter, she's a middle child, but she's the only daughter. So she's never had the experience of being a middle child. She's
like an only child.
She's had it good. Yeah, she's had it really, really good. So she's a good kid though. So all my kids are good kids. So
Well, I think we just do a follow-up episode on this, on like all the best practices for parenting
I could give you a multiple episode series on what not to do.
Yeah, we'll just start there.
It'd be super interesting too. I'd have to check the statute of limitations on a few things, but
Yeah, we'll do that. We'll do our due diligence.
make sure that I'm not incriminating myself in a position where I could be prosecuted. Now, I'm kidding. Okay, well, anything else that you want to say about HIPAA as it applies to dead people right before the holidays?
If you haven't gotten that last minute Christmas gift, just show up with the HIPAA waiver form, and be like, here's your gift. So
And then let us know how that goes. Yeah. Okay, well, happy holidays everyone, and we will catch you next year, 2025, on the next episode.
Thanks everyone. We'll see you.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.